Imagine, if you will, the town square of Falaise, France, in the year 1386. A crowd has gathered, not for a festival or a market, but for a public execution. The condemned prisoner is led to the gallows, but they aren't wearing a hood, and they aren't walking on two legs. This prisoner is a sow, a female pig, dressed meticulously in a man's jacket, breeches, and white gloves. She has been found guilty by a formal court of law for the murder of a human child. To our modern ears, this sounds like a fever dream or a dark comedy sketch, but for the people of the Middle Ages, this was a deadly serious matter of justice. Why did the most sophisticated legal minds of the era spend weeks debating the motives of a pig? Why were rats given defense attorneys, and why were swarms of locusts excommunicated by the Pope? Today, we peel back the layers of the bizarre and fascinating world of medieval animal trials to discover that these absurd spectacles were actually a profound reflection of how our ancestors viewed the universe, morality, and the fragile line between man and beast. Act 1. The scene of the crime and the ritual of law. In the late 14th century, the legal system of Europe was undergoing a period of intense professionalization. In the case of the pig of Falaise, the charges were chilling. The animal had entered a house and attacked an infant, leading to the child's death. In our modern world, such an animal would be destroyed immediately as a matter of public safety. But in 1386, that wasn't enough. The community demanded a trial. The pig was arrested, taken to a dungeon, and held in the same cells as human criminals. A lawyer was appointed to defend her. The trial lasted 9 days. The judge listened to witnesses and evaluated the evidence. When the verdict of guilty was reached, the execution was not a simple slaughter. The pig was dressed in human clothes to symbolize her status as a moral agent who had violated the laws of society. She was dragged through the streets and hanged by the neck until dead. This wasn't an isolated incident. Records show hundreds of similar cases across Europe, from Switzerland to Italy, from Germany to England, spanning from the 12th to the 18th centuries. Animals weren't just killed, they were prosecuted. Act 2. The legal framework, secular versus ecclesiastical. To understand this, we must look at the dual nature of medieval law. There were two types of animal trials. First, there were secular trials, like that of the Falaise pig, involving large domestic animals like bulls, horses, or pigs that had committed specific crimes of violence. These fell under the jurisdiction of civil courts and usually ended in capital punishment. Second, there were ecclesiastical trials, handled by the church. These were brought against pests, rats, weevils, caterpillars, or locusts that were destroying crops. You couldn't exactly hang 1,000 locusts, so the church used spiritual weapons. The pests were summoned to court. When they inevitably failed to show up, they were declared contumacious. A defense lawyer would then argue on their behalf, often suggesting that the insects were merely exercising their God-given right to eat, or that they were a plague sent by God to punish the village's sins. If the defense failed, the priest would perform a ritual of excommunication, cursing the insects and ordering them to leave the territory under the threat of divine wrath. Act 3. The logic of the absurd. Why do it? To a modern observer, a lawyer arguing with a swarm of beetles seems insane. But there was a deep internal logic at play. The medieval worldview was built on the great chain of being, a strict hierarchy where God was at the top, followed by angels, then humans, then animals, plants, and minerals. Everything had its place. When an animal killed a human, it wasn't just a tragedy, it was a cosmic inversion. It was a revolt against the natural order ordained by God. By putting the animal on trial, the community was reasserting human dominance and restoring the rule of law. It was a way to make sense of a chaotic and often cruel world. If you could litigate against a plague of rats, then the world wasn't random. It was governed by rules. Furthermore, these trials served as a powerful moral deterrent for human owners. If your pig was hanged because you failed to fence it in, you felt the weight of that justice personally and financially. Act 4. The Great Defender of Rats. One of the most famous figures in this history is Barthélemy de Chasseneuze, a 16th century French jurist who made his reputation by defending rats. In a famous case in Autun, Chasseneuze was appointed to represent a colony of rats accused of destroying the barley crop. When the rats failed to appear in court, Chasseneuze argued that the summons had been too narrow. It should have been announced in every parish, as the rats were scattered. The judge agreed and delayed the trial. At the next hearing, the rats still didn't show. Chasseneuze then argued that his clients were willing to come, but the journey was too dangerous because the local cats were waiting to ambush them. He claimed that under the law, a defendant is not required to appear if their life is in peril. Through these brilliant, if hilarious, legal maneuvers, he managed to delay the case indefinitely. This story highlights a crucial point. The lawyers didn't treat these as joke cases. They applied the highest standards of Roman and canon law to their animal clients, proving that the law was an absolute, impartial force that applied to all of God's creatures. Act 5. Philosophical Reflections and the End of an Era. Why did this stop? As the Enlightenment dawned in the 18th century, the way we viewed animals changed. Thinkers like René Descartes began to argue that animals were mere automata, mindless machines without souls or moral agency. If a clock breaks, you don't put it on trial, you fix it or throw it away. As the machine view of animals took hold, the idea of a criminal pig became nonsensical. The last recorded animal trial took place in the early 1900s, but the practice had largely died out a century prior. Looking back, we might laugh at the medieval judge sentencing a cow, but there is something hauntingly beautiful about the idea that even the smallest creature was entitled to a defense. These trials were a bridge between a world of magic and a world of mechanics. They remind us that for centuries, humans didn't see themselves as separate from nature, but as part of a single, moral, and legal community with every living thing. The next time you see a pig in a farmyard or a beetle in your garden, remember that there was once a time when they might have been your neighbors in a courtroom. The medieval animal trials weren't just about crazy people doing crazy things. They were an attempt to bring order to the chaos of life and to acknowledge the weight of justice in every corner of the earth. It makes us wonder, as we move into an era of artificial intelligence, will we one day find ourselves back in the courtroom, trying to determine the moral agency of a non-human entity once again? History has a strange way of repeating itself. If you enjoyed this deep dive into the legal oddities of the past, don't forget to like, subscribe, and hit the notification bell for more historical mysteries. Until next time, stay curious.